Hey. Let me turn this down a little bit. This is the first time we're going live, and the purpose of doing this is to let it be known. If you didn't know, you about to find out. Hip Hop Legal, we follow the filings. We'd like to spotlight important complaints, powerful complaints, in legal history, because our goal is to primarily learn. And so we're going to try to tackle this with a new angle in terms of putting out content that'll get the people to simply read, or listen to something as it's read. And here I am, the one and only H. Vanderbilt Alexander, on behalf of Hip Hop Legal. We're going to follow the filings. You hear the music in the background. Get hyped. It's going to be lit. It's going to be live. Let's get to it. So, and I may have to turn the music down a couple times, so please excuse me if anything changes on the screen. But I'll try my best to have the screen go along as I read. But what this is essentially is a second amended complaint, a complaint for declaratory and injunctive relief, Mamandis petition damages. It is case number, as you can see on the top, and also in the middle there, case number 623CV 00003, and this is a jury trial demand. And looking at the top again, it is in the United States District Court for the Southern District of Texas, Victoria Division. And this is a case involving Targeted Justice, Inc., a 501c3 Texas corporation, Dr. Leonard, Burr, Dr. Timothy Shelley, Karen Stewart, Winter Calvert, Armando Delatorre, Jasmine Delatorre, JD, Deborah Manhanger, LM, Lindsay J. Penn, Melody Ann Hobson, Anna Robertson Miller, Yvonne Mendez, Devin Delaney Fraley, HF, Susan Holson, Jen Kang, Jason Frost, and these are the plaintiffs versus, let me let the build-up happen, because I don't know about y'all, but sometimes these, when you read these legal filings, you gotta be a hip-hop head and a legal head. It's just that I think that combination is so dope. That's primarily why we started this whole channel, this whole hip-hop legal movement. But we also get excited from nerdy things, so to speak. You know what I'm saying? Reading, learning, getting invigorated, having that fire be lit up inside you, just from seeing the steps that people take by using the American judicial system, which is the best in the world. We could obviously improve at several different things, but that's another conversation for another time. But something like this has to get you inspired. So let's go through it. Let's jump in. But these are the plaintiffs, and here we have from the top, Merrick Garland, in his official capacity as Attorney General of the United States, Department of Justice, 950 Pennsylvania Avenue, NW, Washington, D.C., 20530. Let me turn the music down a little bit. We also have Federal Bureau of Investigation, 935 Pennsylvania Avenue Northwest, Washington, D.C., 20535. We have Mr. Christopher Wray in his official capacity as Director of Federal Bureau of Investigations and in his individual capacity. We have Charles Gable Jr. in his official capacity as Director of the Federal Bureau of Investigation Terrorist Screening Center and in his individual capacity. We have Department of Homeland Security, located at 245 Murray Lane, Southwest, Washington, D.C. 205, 205, excuse me. So I looked away for a second and I'm lost. I'm sorry, that's 245 Murray Lane, Southwest, Washington, D.C. 205-28-0075. We have Alejandro Mayorkas in his official capacity as Secretary of the Department of Homeland Security and in his individual capacity. Then we have Mr. Kenneth L. Weinstein in his official capacity as Department of Homeland Security's Undersecretary for Intelligence and Analysis and in his individual capacity. And these are the defendants, ladies and gentlemen. So we see clearly there are some big wigs. These are the big boys here, but let's get into the actual complaint. So this is, again, the second amended complaint for declaratory and injunctive relief, mandamus, and damages. In the Honorable Court, now come the plaintiffs, Targeted Justice, Inc., Leonard Burr, Timothy Shelley, Karen Stewart, Winter Calvert, Amanda de la Torre, Berta Jasmine de la Torre, for themselves and on behalf of their minor daughter, J.D., Deborah Manninger, on her behalf and on behalf of her minor daughter, L.M., Lindsay J. Penn, Anna Robertson Miller, Melody A. Hobson, Devin Delaney Fraley, on her own behalf and on behalf of her minor daughter, H.F. Yvonne Mendez, Susan Olson, Jen Kang, and Jason Frost, through their undersigned counsel, and respectfully allege and pray. Number one, introduction. Let me see if I can flip this. Let's see. Looks like I can't. I guess I can't flip yet. Maybe I need to step up my streaming game, but I can't flip. But it's all good. All right, we'll work past it. We'll work through it. So let's see. All right, introduction. Under the guise of national security, agencies of the United States government for decades maintained hidden from the public cruel, illegal, covert human experimentation projects that they subsequently admitted to have carried out on unsuspecting American citizens. Number two, from 1953 to 1966, the Central Intelligence Agency, CIA, sponsored the MK Ultra program to control human behavior. CIA versus Sims, 471 U.S. 159, 1985. The program's stated purpose for that of developing brainwashing and interrogation techniques. Orlikowal versus United States, 682 F Supplement 77 DDC 1988. Unsuspecting subjects underwent long-lasting cruel experimentation without their knowledge or consent. Number three, during 1975-76, Congress carried out an investigation of the MK Ultra program. The Church Committee, under the direction of the director of the late Senator Frank Church, held hearings that resulted in the apparent shutdown of the program. Upon concluding this investigation, Senator Church tried to rein in the corrupted intelligence agencies when he publicly warned everyone that, quote, the National Security Agency's capability at any time could be turned around on American people, and no American people would have any privacy left. If such is the capability to monitor everything, telephone conversations, telegrams, it doesn't matter. There would be no place to hide. If a dictator ever took over, the NSA could enable it to impose total tyranny, and there would be no way to fight back. Close quote. Likewise, Defendant Federal Bureau of Investigation, FBI, COINTELPRO program that started in the 30s was designed to crush political opposition using illegal surveillance and persecution tactics. In Puerto Rico, its effects were particularly devastating as the program known as Las Carpetas, the dossier, quote unquote, was, quote, used to imprison people, ruin their careers, fire them from their jobs, terminate their education, and permanently discredit over 74,000 of them. It was used to control the politics and society of Puerto Rico through fear, intimidation, and outright blackmail. See also Noriega versus Gorbinator, 112 DPR 650 1988 WL 580739 PR 1988 PR ENG 5873922 PR official transcript 613. Number 6. It's paragraph number 6 if you're following along. In the year 2000, speaking before Congress about the COINTELPRO and Las Carpetas, defendant FBI then Director Louis J. Freech admitted in a House Appropriations Subcommittee that the FBI did not operate, quote unquote, a program that did tremendous destruction to many people. Let me read that again because the details are important. I said not, and that wasn't in there, but it says the FBI did operate a program that did tremendous destruction to many people. To the contrary, and certainly to the FBI, Freech then vowed to, quote unquote, redress some of the egregious illegal action, maybe criminal action, that occurred in the past. Close quote, emphasis ours. Paragraph number 7. Assessing the destruction of so many lives that the FBI's COINTELPRO program caused in Puerto Rico, the island's highest court expressed, when a person's dignity, quote unquote, and reputation be unlawfully touched by the government simply because he exercised his fundamental rights as guaranteed by the Constitution, his innermost being must have an avenue for redress to repair the damage done to his dignity and honor. In our democratic system of government, it is incumbent upon the courts to address such claims and to design remedies to mitigate the irreplaceable harm caused to a citizen by reason of the government's outrages. Noriega versus Gobernador. Supra. Emphasis supplied. No single individual at the at defendant FBI or the CIA, was ever criminally responsible for the obliteration of so many lives perpetrated under any of these two programs. Paragraph 9. Today, defendants FBI and DHS jointly collaborate with other illegal covert human experimentation persecution programs, a hybrid behemoth that combines MK Ultra and COINTELPRO's Las Carpetas. Labeled with the nondescript moniker of quote-unquote the program, its global scope aims to control and destroy opposition. Hundreds of thousands of American citizens and lawful U.S. residents, such as the plaintiffs and TJ members, have been subjected to, or rather on a continuous and uninterrupted basis, to this legal program funded with billions of American taxpayer money. Plaintiffs request that the court take judicial notice of the fact that the Committee on the Judiciary of the House of Representatives convened on January 10th, 2023, led by Representative Jim Jordan, currently leads the effort to investigate inter alia, defendant FBI's abuse in the weaponization of the government against U.S. persons. Paragraph number 11. Defendants have announced that they will engage in an effort to hide from plaintiffs in the courts the evidence germane to the claims set forth in this case by alleging secrecy of national security concerns, while disrespectfully dismissing the merits of the complaint as quote-unquote baseless allegations and conspiracy theories. Just like their predecessors tried to sweep MK Ultra and COINTELPRO under the rug. Number 12. Defendants cannot hide evidence under its exclusive control germane to plaintiffs' claim under the guise of secrecy because of Executive Order 13-52526 provides that, quote, in no case shall information be classified, continue to be maintained as classified, or fail to be disclassified in order to conceal violations of law, inefficiency, or administrative error. Ergo, defendants cannot erect a wall of confidentiality to cover up their blatantly illegal, unconstitutional, and or criminal conduct. Number 13. On April 26, 2011, former FBI senior agent in charge, senior special agent in charge, that is, Ted Gunderson, RIP, stated in an affidavit and under penalty of perjury that thousands of innocent victims have been targeted by an illegal government ongoing, active, nationwide, rogue criminal enterprise that is active 24 hours a day within the United States, whose increase in scope, intensity, and sophistication was made possible by the new communications and surveillance technologies. See Exhibit 1, Plaintiffs request that the court take judicial notice of the statement under penalty of perjury filed within the case Labella v. Federal Bureau of Investigation 11CV 0023 NGG LB EDNY March 16, 2012. Number 14. Pursuant to Gunderson, individuals in the nefarious program are referred to as quote-unquote targets. They are subject to illegal, unconstitutional phone taps, illegal rerouting of business and private phone calls for harassment purposes, surreptitious entry into home, office, and vehicle, virtual surveillance in the home conducted by illegal placement of miniature remote wireless cameras, often accessible through the internet, illegal internet spyware, illegal GPS tracking, often through their own mobile phones, regular fixed and mobile surveillance, mail misdirection, mail theft and tampering, financial and employment sabotage, slander campaigns, poisoning, assaults and murder, illegal setups on drug charges, and other felony charges, amongst other civil rights abuses, close quote. Number 15, paragraph number 15. Technological advances have been incorporated into the illegal organized stalking and surveillance, including the use of microwave weapons for inflicting physical and psychological torture that ends up causing them the conditions known as Havana syndrome, remote neural monitoring, and voice-to-skull auditory symptoms, as well as microwave burns. Number 16. For decades, an impenetrable wall of quote-unquote plausible deniability camouflaged perpetrators, continuous crimes against targets. The program's sophistication prevented victims from identifying with clarity the abusers and tortures perpetrated against them and from articulating the mechanisms by which these abuses and tortures were being deployed and executed. Any target who identified or attempted to report the abuses and torture were accused of being mentally ill. Rather than commencing investigations into these serious crimes and prosecuting the perpetrators for their criminal conduct, federal, state, and tribal law enforcement agencies colluded to institutionalize its victims and declare them mentally ill or incompetent. Paragraph number 17. Plaintiffs and TJ members, hundreds of substantially similar accounts counteract the program's cornerstone, that is, quote-unquote plausible deniability, that allowed its unchecked, continuous, and uninterrupted. Bear with me. I'm holding the phone with one hand. We got to come up with a better way of doing this, but we're just trying out the first one here. So, that allowed its unchecked, continuous, and uninterrupted operation for decades that persists today. Defendant FBI, Ray, and Cable are the gatekeepers of the targeted individual program that obtains its experimental subject roster from two secret, unconstitutional subcategories embedded within the Terrorist Screening Database, TSDB. Number 19. The TSDB's only source of legal authority is Homeland Security Presidential Directive, quote, HSPD-6, close quote, Exhibit 7. HSPD-6's unambiguous stated purpose is to develop, integrate, and maintain thorough, accurate and current information about individuals known or appropriately suspected to be or have been engaged in conduct constituting, that is, in preparation for, in aid of, or related to terrorism. Terrorist information, close quote. Number 20, HSPD 6 expressly mandated strict compliance with the provisions of the Constitution and applicable laws, including those protecting the rights of all American citizens. Exhibit 7. Number 21, HSPD 6 did not give authority to any official or agency of the United States to include in the TSDB the names of people that do not meet the terrorist criteria. Despite this, defendants Ray and Cable, acting under color of law, included and or maintain names within the TSDB names that belong to non-investigative subjects, NIS, such as plaintiffs and TJ members that do not meet the required terrorist criteria. Number 22. The stated purpose of the intra-agency operation under defendant FBI's umbrella in charge of crafting the TSDB, the Terrorist Screening Center, TSC, was to, quote-unquote, ensure that American government screeners are working from the same unified set of anti-terrorist information and will provide a comprehensive anti-terrorist list when suspected terrorist is screened or stopped anywhere in the federal system. Exhibit 8, emphasis hours. Number 23. Despite the clear and limiting text of HSPD-6, I keep saying slick, my bad. Defendant FBI has admitted that the TSDB contains names of people with no ties to terrorism. In a statement given under penalty of perjury in El Hadi versus Cable, 391F Supplement 3D 3562 EDVA 2019, revised 993 F 3D 208 2021, former TSC Deputy Director Timothy Groh expressed that the TSDB contains information on individuals who constitute an exception to the reasonable suspicion standard and who are not considered known or suspected terrorists. They are not screened as such, close quote. Exhibit 2, emphasis hours. Groh's specific words were the following. And bear with me 1 second, because I got to set up this phone another way. Can't keep holding it throughout this whole thing. So, we're going to figure this out. Hang on. Alright, I still got it in my hands. Hopefully it's straight down the middle, but I'm gonna read it. Let's see, okay. Number 24, Groh's specific words. Okay. Groh's specific words, Exhibit 2, were the following. Additionally, the TSDB includes identifying information of certain individuals who are not categorized or known as suspected terrorists, emphasis ours. Now, as you can see, there's some other text at the bottom. Okay, limited exceptions to the reasonable suspicion standard exist for the sole purpose of in supporting, that is, certain screening functions of DHS and state, such as determining eligibility for immigration to the United States. Individuals included in the TSDB pursuant to such exceptions are not considered known or suspected terrorists and are not screened as such. As a result, any U.S. person who is in the TSDB pursuant to an exception to the reasonable suspicion standard would not be required to undergo heightened aviation security screening at airports on the basis, but could be selected for an unrelated reason such as random selection, emphasis ours. Handling codes 3 and 4, subcategories of the TSDB that constitutes 97 of the identifies 97 of the identities of the entire database. Hereinafter, TSDB NIS McCarthy blacklist, close quote, quote unquote, hence that Grow called limited, quote, limited exceptions, close quote, to the KST listed in the database. Let me turn this down a little bit more. Maybe I'll turn it off for a little bit for now. The music's kind of annoying. Sorry about that. Just trying to add the climactic, feel to it. You dig? All right, number 26. Even though 17 of 18 individual plaintiffs and TJ members are American citizens and one is a legal resident, none meet the terrorist criteria. Okay. Only one, the legal resident, could be conceived as a subject to the special screening functions of the DHS and state, close quote unquote. Defendants FBI, Ray, and Cable and their predecessors legally and under color of law and or in the abuse of discretion included and or maintained plaintiffs' names within the TSDB, NIS, McCarthy blacklist despite the lack of derogatory information linking them to acts of terrorism. Number 27. Defendants FBI, Ray, and Cable, acting under color of law, have disregarded, that is, their oath and obligation to adhere to the limited scope of HSPD and to uphold the laws and Constitution of the United States. Instead, they have secretly included in the roster of the TSDB hundreds of thousands of innocent NIS or U.S. persons, such as plaintiffs and TJ members, that do not meet the terrorist criteria. Number 28. In the exercise of their official duties and acting under color of law, defendants Ray and Cable abuse their discretion and violate their oath and the Constitution by illegally deciding upon the faith of unsuspecting individuals such as plaintiffs and TJ members and including them in the TSDB even when they do not meet the terrorist criteria. Number 29. By including plaintiffs and TJ members' names in the secret non-terrorist McCarthy blacklist embedded within handling codes 3 and 4 of the TSDB, defendant FBI, Ray and Cable, acting under color of law and under the guise of quote-unquote national security, have secretly, unconstitutionally, and maliciously sentenced the former to undergo a lifetime of covert human experimentation that targets and tortures them in many instances to their death. I'm just going to emphasize that by reading it one more time. Just that last line. And maliciously sentenced the former to undergo a lifetime of covert human experimentation that targets and tortures them in many instances to their death. Let that sink in. All right, paragraph 30. Without sufficient grounds to link an individual to terrorism, an unwitting person's placement in the TSDB NIS Handling Codes 3-4 list is the equivalent to being indicted, tried, and sentenced to a lifetime of torture and physical and psychological abuse in violation of the United States Eighth Amendment prohibition against cruel and unusual punishment, the Convention Against Torture, and the Geneva Convention. Number 31. Thus, acting under color of law, defendants Ray and Cable become virtual jailers in an inescapable gulag, placed and maintaining innocent civilians, such as plaintiffs and TJ members, in a lifetime torture program by secretly and arbitrarily adding their name in the illegal TSDB's McCarthy blacklist. Number 32. Defendants' unrestricted inclusion of the individuals such as plaintiffs and TJ members in the TSDB NIS McCarthy blacklist has resulted in huge swaths of the population that have nothing to do with terrorism activity to be permanently included without notice or consent to the McCarthy blacklist that serves as a roster for an atrocious human experiment torture program that ensured the cooperation and admitted CIA's MK Ultra and FBI's COINTELPRO. Number 33. Stated another way, Ray and Cable, acting under color of law, have created two illegitimate categories within the TSDB to include the names of hundreds of innocent thousands of American citizens and legal residents that are not known or suspected terrorists for no purpose other than secretly enlisting them in an involuntary human experimentation program that targets unsuspecting victims, divesting them of their autonomy and destroying their lives with no recourse. Number 34. After years of unrestricted abuse, an unprecedented number of people, such as plaintiffs and TJ members, have emerged to publicly expose their experiences during enduring these criminal attacks that go unstopped and unpunished. The cloak of invisibility that for decades shielded the program for from shielded the quote unquote program from scrutiny no longer exists due to the sheer number of targeted individuals estimated in the hundreds of thousands within the U.S. territory. Number 35. Plaintiffs and TJ members are victims and survivors of defendants' FBI's, Ray's, Cable's, Mayorkas's, and Weinstein's deprivation of the former fundamental constitutional, civil, and human rights while acting under color of law. Number 36. Plaintiff come before this court to petition for redress of their grievances and protection from these shocking abuses, to request that this court declare illegal and unconstitutional the NIS handling codes 3-4 subcategories of the TSDB, to request that this court issue an injunction ordering the elimination of the McCarthy blacklist contained in the TSDB's handling codes 3 and 4. In the alternative, to request that plaintiff and TJ members' names be removed from the TSDB handling codes 3 and 4, to order defendants to comply with the duties of the laws, treaties, and Constitution of the United States, their positions imposed on them, and to hold defendants jointly and severely liable under the various theories and statutory authorities for the atrocious damages they've caused the plaintiffs as a result of their improper inclusion on the TSDB McCarthy's blacklist, and consequently submitting them to an outrageous, vicious, and illegal tortures and constitutional violations that they have endured as targeted individuals, that is. Now let's talk about the jurisdiction, or rather, let's read about the jurisdiction and venue. Turn the volume up. It's a movie. All right. Number 37. The court has federal question jurisdiction under 28 U.S.C. 1331 because this action arises under the Constitution, laws, and treaties of the United States of America. 28 U.S.C. 1346A2 because it includes claims against the agencies of the United States. Article 3, Section 2 of the United States Constitution because the rights sought to be protected herein are secured by the United States Constitution. The Menendez Act, 28 U.S.C. 1361, the court's equitable jurisdiction to issue an injunction to compel an officer or employee of the above-named federal agencies to perform his or her duty under Federal Rules of Civil Procedure 65 and 28 U.S.C. 1361, and the United Nations Convention 1753 against torture and other cruel, inhumane, or degrading treatment or punishment, ratified by the United States of America in 1994. Quote, Convention Against Torture, close quote, and Article 32 of the Convention for relative to the protection of civilian persons in time of war, Geneva, 12 August 1949. Ratified by the United States on February 8th, 1955, quote, Geneva Convention, close quote, that is enforceable against the United States as per the uninterrupted state of war declared on October 2001. Number 38. The court has authority to grant declaratory and injunctive relief and award damages, costs, and attorney's fees against defendants pursuant to the Declaratory Damage Judgment Act 28 USC 2201-2202, Rules 57 and 65 of the Federal Rules of Civil Procedure, the Administrative Procedure Act, APA, 5 USC 706, the Privacy Act, 5 USC 552, A 4B, and 28 USC 1361, and 28 USC 2412, and 5 USC 552, A4E1. Since this action is brought against officials of the United States acting in their official and individual capacity, as well as agencies of the United States. Number 39. This court also has jurisdiction to award damages and attorney's fees and costs pursuant to 28 USC 1343, A4, and 28 USC 1357, and Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics, 403 U.S. 388, 1971. At sequential, I think, and plaintiffs' civil rights claims arising from defendants' actions under color of law that have deprived them of constitutional rights protected under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution, the Convention Against Torture, and the Geneva Convention. Number 40. Prior to the filing of this complaint, plaintiffs served on defendants Ray, Cables, Mayorkas, and Garland a demand letter with the intent of avoiding filing most of the claims included in the case at bar. See Exhibit 3. None of the defendants replied to it. Number 41, paragraph number 41. Prior to the filing of this complaint and on the date specified in paragraph 71 below, most of the named individual plaintiffs set defendants FBI, DHS, and or U.S. Department of Justice, U.S. DOJ Privacy Act requires under 5 U.S.C. 552, requesting them to provide them with their TSDB records and to remove their names from it. Defendants FBI, DHS, and or U.S. DOJ failure to provide each individual plaintiff an adequate reply under the Privacy Act compelled the filing of this complaint. Venue is proper under U.S. 28 U.S.C. 1391 B2 and E1B because a substantial part of the events or omissions giving rise to the claims set forth herein occurred within the Southern District of Texas. Plaintiff Targeted Justice is a Texas corporation, and 11 of the 18 individual plaintiffs reside in the Southern District of Texas. Therefore, most of the events or omissions giving rise to the claims set forth herein occurred within this venue. Number 3, plaintiffs. Number 43, Targeted Justice, Inc. is a 26 U.S.C. 501c3 nonprofit, nonpartisan Texas corporation that represents the interests of targeted individuals, TIs. TJ's mission is to educate the public with information, news, and support for the TIs to help them navigate through the trauma and destruction that this phenomenon produces in their lives. TJ's goal is that of stopping the illegal surveillance, organized stalking, and global use of directed energy weapons, torture against civilians within the United States. TJ appears on its own behalf and on behalf of its over 3,500 members, quote-unquote TJ members. Number 44, TJ maintains the website http www.targetedjustice.com and publishes a newsletter at targetedjustice.substack.com to disseminate news and information on matters of public interest and practical advice relating to the targeting of individuals. Its website averages 120,000 page visits per month. It has memberships of over 3,500 individuals that have sustained and continued to suffer injury in fact because of defendants' illegal and unconstitutional acts and omissions in the course of their official duties. Number 45. On February 12, 2019, Targeted Justice sent a cease and desist letter to defendants FBI, Cable, U.S. DOJ, DHS, and demanding that they immediately cease and desist to use their government personnel and or external groups to commit organized stalking activities against targets, attacking civilians with psychological torture techniques, including stalking, gang stalking, harassment, and intimidation. None replied. For the declaratory judgment and injunctive relief portions of this complaint, TJ appears on behalf of hundreds of its members who submitted information demonstrating that they sustained injury, in fact, as a result of being unjustly included in the TSDB. I'm going to clear my throat real quick. Let me clear my throat. Have mercy, babe. I hope you don't mind. Let me clear my throat. It says hip hop legal. Gotta have a hip hop in there. All right. Individual plaintiffs. Number 47. Plaintiff Dr. Leonard Burr, of legal age, single U.S. citizen, medical doctor, resides in Bloomingdale, Illinois, and is a member of Targeted Justice's Advisory Board. Plaintiff Burr became aware that he was a TI on or about 2019. Plaintiff Burr came to the United States in 1993 on an H-1B visa, and in 2003 became a naturalized citizen of the United States. Because of our nation's dedication to the Western principles, its history, the Constitution, and the Declaration of Independence. An immigrant from a totalitarian regime, it never occurred to Plaintiff Burr that he would encounter governmental operatives acting in contravention of the Nuremberg Code and Article 32 of the Geneva Convention, violating their civil rights and their presumption of innocence. Plaintiff Burr suffered debilitating daily directed energy weapons, DEW, quote-unquote, attacks, and has been diagnosed with Havana syndrome. Number 48. Plaintiff Karen Stewart, of legal age, is a United States citizen, married, retired National Security Agency, NSA, that is, and, excuse me for that burp, NSA intelligence analyst residing in Columbia, Maryland. Ms. Stewart is a NSA whistleblower that believes became a TI in around 2006. Number 49. Dr. Timothy Shelley, of legal age, United States citizen, single investigative journalist, and attorney at law, is a resident of Kennett Square, Pennsylvania. Plaintiff Shelley realizes that he was a TI in 2016. However, he believes his targeting began decades before. Number 50. Plaintiff Winter Calvert, of legal age, single in the United States, is a United States citizen, engineer, and resident of Houston, Texas. On information and belief, Mr. Calvert has been a TI since at least 2011. For over 25 years and throughout his activism on behalf of targeted individuals and began in 2017. Plaintiff Calvert has also been known as Richard Lighthouse. Number 51. Plaintiffs Armando De La Torre and his wife Berta Jasmine De La Torre are married to each other, are TIs since 2019. Armando is a U.S. citizen and Berta Jasmine is a legal resident of the United States. They are residents of Alvin, Texas. They sue on their behalf and on behalf of and custodians of their minor daughter, J.D., born in 2019 and a United States citizen. Due to her tender age, it is impossible that J.D. could represent a national security concern or be a TI. Like her parents, 3-year-old J.D., 3-year-old J.D., 3-year-old J.D., 3-year-old J.D., 3-year-old J.D. is the victim of targeting since at least August 2022. They tripping, man. Excuse me for that added little portion there. Just wanted to emphasize that. Number 52. Plaintiff Deborah Joanne Manhager, of legal age, United States citizen, former FBI agent, mother, is a resident of New Hampshire. She became aware that she was a TI on or about 2019. Plaintiff Manhager also appears on behalf and as a custodian for her 8-year-old daughter, 8-year-old daughter, 8-year-old daughter, 8-year-old daughter, L.M, who was also a TI. Number 53. Plaintiff Lindsay J. Penn, also known as Lindsay Mack, and Lindsay Allwaltz, of legal age, United States citizen, married, assistant real estate broker, mother, and soccer coach in the United States, and a United States citizen and resident of League City, Texas. Although her targeting began on or around 2014, she became aware of it in 2016. Paragraph 54. Plaintiff Melody Hobson, of legal age, United States citizen, single mother, resident of Deer Park, Texas, became aware she was a TI around 2020, although she believes her targeting began on or around 2014. Paragraph 55. Plaintiff Anna Robertson Miller, of legal age, United States citizen, married paralegal, mother, and resident of Cypress Creek, Texas, became aware in 2016 that she was a TI, but believes her targeting could have begun as far back as 2013. In 2019, Ms. Miller began enduring gruesome DEW attacks. Number 56. Plaintiff Yvonne Mendez, of legal age, United States citizen, single mother, and resident of Houston, Texas, believes she has been a TI for over 19 years. Paragraph 57. Plaintiff Devin Delaney Fraley, of legal age, United States citizen, mother, resident of San Antonio, Texas, that is, became aware that she was a TI in 2016, but that her targeting began years before. In 2019, she stated, maybe that's not the best music for this moment. In 2019, she stated, or rather, she started enduring DEW attacks and experiencing V2K. She appears on her behalf, as well as her 3-year-old daughter, 3-year-old daughter, 3-year-old daughter, 3-year-old daughter, HF, who began showing symptoms of DEW attacks immediately after the filing of the case at bar in January 2023. Number 58. Plaintiff Susan Olson, of legal age, United States citizen, single, attorney at law, resident of East New Brunswick, New Jersey, became aware she was a TI in 2015, but recognizes he may I'm sorry. Okay, I skipped a section. So number 58 again. Plaintiff Susan Olson, of legal age, United States citizen, single nurse, resident of Fort Myers, became aware she was a TI in 2015, but recognizes that she may have been a TI for a longer time since she resided in New York. Number 59. Plaintiff Jin Kang, of legal age, United States citizen, single, attorney at law, resident of East New Brunswick, New Jersey, became aware he was a TI in 2015, but recognizes he may have been a TI for a longer time. Number 60. Plaintiff Jason Faust, of legal age, United States citizen, single, anthropologist, resident of Houston, Texas, became aware in 2016 that he was a TI, though he believes his targeting began at least 2015. Defendants. Number 61. Defendant Federal Bureau of Investigation, FBI, quote unquote, is the agency under whose purview its Intra-Agency Operation Terrorist Screening Center, TSC, operates. It is liable to plaintiffs for having incurred an arbitrary agency action in the context of its responsibility of preparing and maintaining the Terrorist Screening Database, TSDB, colloquially known as the watch list, quote unquote. Failing to observe the executive orders, laws, and Constitution of the United States, failing to adhere to and follow and its own regulations and procedures, failing to timely and thoroughly answer Plaintiff's Privacy Act requests, and disseminating to persons outside of the agency false information on plaintiffs within the agency's control. It is brought as defendant in the case for inter alia its violations of the Constitution and laws of the United States, violations of the Privacy Act for obtaining and executing illegal FISA warrants against plaintiffs, for carrying out illegal, warrantless, quote unquote, sneak and peek searches and seizures in plaintiffs and TJ members, properly devoid of illegal grounds to do so, for carrying out illicit surveillance, for carrying out illicit, quote unquote, assessments on plaintiffs, on information and belief for paying third parties to carry out illegal surveillance, undercover persecution, and crimes against plaintiffs and their property. Number 62. Defendant Department of Homeland Security, quote unquote DHS, is the agency vested with the responsibility of funding, creating, and approving the standard operating procedures implemented in the Fusion Center network, carries out rogue, unconstitutional, and illegal practices against plaintiffs and TJ members as part of the human experimentation, quote unquote, program. Defendant DHS is also responsible for answering Plaintiffs' Privacy Act requests and protecting from dissemination false information on plaintiffs within the agency's control. DHS is made a defendant in the case for its failure to comply with the laws and Constitution of the United States, violations of the Privacy Act, and for the continuous, uninterrupted, and considerable damages its policies, orders, and indirect funding through grants of the regional network of fusion, and indirect funding through grants of the regional network of fusion centers have caused plaintiffs as victims of the quote unquote program. All right, paragraph number 63. Excuse me if I wasn't listing them before. I was just kind of reading. Got in the zone there. But paragraph number 63. Defendant Christopher Wray is defendant FBI's director who, under the color of law, has exercised oversight and control over the procedures of the FBI, the TSC, and its product, the TSDB, as well as citizen organizations in Infragard, that routinely, continuously, and in common concert in conjunction with defendants FBI and DHS terrorize and persecute NIS such as plaintiffs and TJ members as part of the program, in violation of their rights protected under the 4th, 5th, 6th, and 8th Amendment of the United States Constitution. Acting under color of law, defendant Ray has violated his ministerial duty to ensure all procedures within defendant adhere to the laws of the Constitution of the United States, disregarded agency audit reports. He is personally liable to plaintiffs for the nomination to and or maintenance of the TSDB McCarthy lists comprised of handling codes 3 and 4, causing and or enabling the deprivation of their substantive and procedural due process rights contained in the 5th, 6th, and 14th Amendments of the United States Constitution, and their right to be free of torture under the Convention against. I'm gonna make an adjustment to the phone here. Still got it in my hands. Got to get a case or something. We'll figure it out. It's a work in progress. Thank you for still sticking around if you're interested in this kind of content. But literally, we're just reading the complaint. Let's see. Okay. Against torture, including their names in the TSDB, despite the required derogatory information for doing so. He is sued both in his official and individual capacity. Paragraph 64. Defendant Attorney General Merrick Garland has a ministerial duty of ensuring all procedures and regulations at defendants, the FBI and DHS, as well as at the Fusion Center Network, adhere to the laws of the Constitution He disregarded of his ministerial duties in the oversight of the TSC and in preparation, maintenance, and use of the TSDB, coupled with their own actions under color of law, prompted his inclusion in the case. He is personally liable to plaintiffs for failing to prevent plaintiffs and TJ members' illicit inclusion in the TSDB McCarthy blacklist and deprivation of substantive and procedural due process rights contained in the 5th, 6th, and 14th amendments of the United States Constitution. Furthermore, his disregard of the ministerial duties inherent to his position has enabled and perpetuated plaintiffs and TJ members targeting unauthorized experimentation and torture in violation of their rights under the 4th and 8th Amendments of the United States Constitution, as well as their right to be free of torture under the Convention Against Torture and Article 32 of the Geneva Convention. He is sued both in his official and individual capacity. Paragraph number 65. Defendant Charles Cable is the TSC director who was responsible for the maintenance and dissemination of the federal government's TSDB. Under color of law, Defendant Cable illicitly accepts and promotes TSDB nominations and maintains names in the NIS such as plaintiffs, TJ members, and other similarly situated American citizens, even though they do not meet the required derogatory criteria to be categorized as a terrorist, in violation of their substantive and procedural due process rights contained in the 5th, 6th, and 14th amendments of the United States Constitution. The Convention Against Torture and Article 32 of the Geneva Convention. Under color of law, Defendant Cable also oversees, along Defendant Ray, the dissemination of the stigmatization TSDB label imposed on plaintiffs, TJ members, and other similarly situated American citizens to state and local authorities, foreign governments, private corporations, private contractors, airlines, gun sellers, car dealerships, financial institutions, the captain of seafaring vessels, and other official and private entities and individuals. Defendant Cable is personally liable to the plaintiffs by placing and or maintaining their names in a McCarthy blacklist within the TSDB devoid of the required derogatory information and by enabling their targeting, unauthorized experimentation, and torture in violation of their rights under the 4th, 8th Amendments of the United States Constitution, as well as their right to be free of torture under the Convention Against Torture in Article 32 of the Geneva Convention. He is sued both of his official and individual capacity. Paragraph number 66. Defendant Alejandro Mayorkas is defendant's DHS secretary, responsible for the oversight of his agency's collaboration with defendant FBI and TSE for the nomination process of individuals to the TSDB and the sharing of plaintiffs and TJ members' private information throughout the Fusion Center network. Defendant Mayorkas is also sued in his individual capacity as the official responsible for the supervision and implementation of unconstitutional operating procedures at the national network of fusion centers that implement the illegal organization and systemic surveillance and stalking procedures carried out against plaintiffs and TJ members as part of the targeting program. He is personally liable to plaintiffs for causing and or enabling the deprivation of their substantive and procedural due process rights contained in the 5th, 6th, and 14th Amendments of the United States Constitution, and by enabling their targeting, unauthorized experimentation, and torture in violation of their rights under the 4th and 8th Amendments of the United States Constitution, as well as the Convention Against Torture. He is sued both in his official and individual capacity. Defendant Kenneth L. Weinstein is defendant DHS's Undersecretary for Intelligence and Analysis. He provides the Secretary, DHS Senior leadership, DHS component, and state, local, tribal, territorial, and private sector partners, and Homeland Security intelligence and information used in their operations. He is sued in his official as well as his individual capacity, since under color of law he carries out the supervision and control of the organized stalking endeavors perpetrated against plaintiffs and TJ members to terrorize and torture them through the Fusion Center Network, Citizens Corps, and other community watch organizations financed through defendant DHS in violation of the rights protected under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution, the Convention Against Torture, and Article 32 of the Geneva Convention. Now let's get into legal and factual background. Number 68. The foregoing allegations are re-alleged and incorporated therein. Paragraph number 69. Plaintiffs serve on defendants Garland, Ray, Cable, and Mayorkas a notice of writ of mandamus demand letter dated December 21st, 2022, pardon me, in an effort to carry out reasonable diligence to prevent the filing of this complaint. See Exhibit C. Paragraph number 70. Plaintiffs have expended the due diligence to unearth the quote-unquote what element of the quote-unquote who element surrounding the illegal human experimentation targeting program. Paragraph number 71. To initiate a non-existent redress procedure, the individual plaintiff served on defendant FBI and defendant DHS Privacy Act request asking for information about their inclusion in the TSDB under the agency's control. Plaintiff's requests were sent on the following dates. There you can see dates as they are listed for each plaintiff. So we're going from anywhere in November of 2022 to December of 2022. These letters were sent out to DHS, FBI, as well as the DOJ. Same thing continuing down until M. But here we are at paragraph 72. Defendant FBI and or defendant DHS refused to produce meaningful information in response to plaintiff's Privacy Act request. On most occasions, defendant either denied having, let's check out, see some music to get behind this. Gotta make a vibe, you know? Yeah, I think this work right here. It's the drama-filled section, you dig? Think of it like a movie. Defendant FBI and or defendant DHS refused to produce meaningful information in response to plaintiff's Privacy Act request. On most occasions, defendants either denied having any responsive documents and or information or included a generic Lomar denial stating that the agency cannot confirm or deny, quote-unquote, any information requested. Number 73. As recent as March 3rd, 2023, defendant DHS changed the language in its response to a Privacy Act request, as it set forth in the reply sent to plaintiff Lindsay Penn. Quote, as it relates to your request for information on the TSDB, please be aware that information incorporated from the TSDB and or WLS is information that is categorized as sensitive security information, SSI, under 49 U.S.C. 11.4R and the implementing regulation found at 49 CFR Part 1, Part 1520. Records containing SSI are not available for public inspection or copying, nor can they be released to anyone who does not have an official need to know under 49 CFR 1529A2 and 1520-15A. After weeks of regulatory period, after weeks of the regulatory period, I'm gonna turn it down a little bit, to acknowledge and process appeal, and in an effort to make her Privacy Act premature, on March 13th, 2023, that is, defendant DHS replied to plaintiff Stewart that it was acknowledging, quote-unquote, her appeal submitted on blank, and that it would take an undetermined amount of time to adjudicate it. Number 75. Defendant's refusal to adequately reply to plaintiff's Privacy Act request constitute a concealment mechanism directed at preventing them from uncovering the full spectrum of illegalities, that is, players and critical facts of the illegal secret human experimentation made possible by their initiatives, policies, and collaboration. Number 76. Courts have held that, quote, the government has a general policy for not disclosing TSDB status, whether positive or negative, in response to inquiries, because disclosures would disrupt and potentially destroy counterterrorism investigations because terrorists could alter their behavior, avoid detection, and destroy evidence. El Hadi versus Cable, 993 F3D 2008 2021. Number 77. Since plaintiffs and TJ members' names are included at NIS under the TSDB handling codes 3 and 4 and not as KST, the grounds that justify secrecy of TSDB information as set forth above does not apply to them due to defendant FBI's own admission that individuals included in those categories do not represent a terrorist threat, close quote. Thus, defendant's refusal to provide plaintiffs the requested personal information under their control is a violation of the Privacy Act. Number 78. Pursuant to defendant's, quote, open quote, the redress operating procedures manual, close quote, the TSDB is a sensitive but unclassified database and does not contain any derogatory information. Number 79. Defendant FBI and DHS's incomplete response to plaintiff's Privacy Act request or lack thereof also violates Executive Order 13526 that prohibits the classification of information to conceal violations of law or prevent embarrassment to the agency. Executive Order 13526 Section 1-7 precludes defendants FBI's and defendants Ray and Cable acting under color of law from shrouding under a cloak of secrecy the McCarthy blacklist embedded within the TSDB's handling code 3 and 4 and the targeted experimentation program that feeds off of it. This EO states in pertinent part, Section 1-1.7 point classic, Section 1.1-1.7, sorry about that, classification prohibitions and limitations. A. In no case shall information be classified, continue to be maintained as classified, or fail to be declassified in order to, number 1, conceal violations of law, inefficiency, or administrative error. Number 81. Defendant's failure to reply to the demand letter dated December 21st, 2022, sent on behalf of TJ and the plaintiffs prompted the filing of this second amended complaint. Defendant's interagency scheme. Okay. Paragraph number 82. HSPD-6 authorized the Attorney General to create the TSC to consolidate the federal government's approach to terrorism screening and to provide for the appropriate and lawful use of terrorism, or rather terrorist information, in screening processes. Exhibit 8, that is, the stated purpose of the TSC was to ensure that America's government screeners are working from the same unified set of anti-terrorist information and will provide a comprehensive anti-terrorist list with a suspected terrorist when a suspected terrorist, that is screened or stopped anywhere in the federal system. Paragraph 83. The TSC is an interagency operation under the control of defendant FBI, but also involves defendant DHS and other agencies in the United States government. Under the purview of defendant Ray and Cable, acting under color of law, the TSC is responsible for the creation and maintenance of the TSDB, a centralized collection of information to exclusively include and monitor. Let me turn the volume down again. Sorry about that. I was just going in my zone. I feel like it might be annoying to some people, so I turned all the way down. But let's see. And I lost my location. I believe I was at 84, no? All right. Number 80, paragraph number 84. By defendant FBI's own admission, the TSBDB handling code 3 and 4 categories contained the names of people such as plaintiff and TJ members that do not meet the terrorist criteria and are not screened as such. Exhibit 2. Paragraph 85. That their ever growing list of individuals, the TSDB-NIS list exceeds the legal authority delegated to defendant FBI and its TSC and HSPD 6 by including non terrorists in a terrorist screening database without executive or congressional approval. Paragraph 86. And I tell you what, that's page 24. I told myself I'm going to stop at page 25. So we'll just call this part one. This is part one, and we're talking 125 page amended complaint here. So thank you for sticking around. We're just gonna keep doing it. You know what I'm saying? And shoot, if no one watches now, I'm sure at some point they'll watch. But the goal here is to just continue to try to use what we have offered to us as American citizens to try to gain some relief, and try to get some understanding of just how to use the system to our advantage or to our benefit. Because everyone, in my opinion, just has the right to be free in this country. Uh, you know, that's clearly listed in the Constitution. But we're seeing here, and again, this plays out like a story. I like to read complaints from almost a story standpoint, or like a book, or even a movie. So what do we have here? All these people that have been listed as plaintiffs versus the defendants. Defendants primarily seem to be individual entities within the government that have created this program that targets the plaintiffs. And we're seeing here the details in terms of who and what. But that's a very important component as it applies to the law. You want to lay it all out because, again, this is being written for a judge to read. So, you want to kind of get to the point, but still be succinct and also thorough in terms of presenting like how it all played out. So let's read paragraph 86, and I think we'll stop after that. But paragraph 86, by including names of terrorists in the TSDB authorized only for terrorist information, defendant FBI and defendant Ray and Cable, acting under color of law, weaponized the TSDB into a McCarthy blacklist replete with the names of innocent individuals such as plaintiffs and TJ members that has been illegally included under its handling codes 3 and or 4, continuously targeted and at the burp there, and unwittingly made part of an abysmal human experimentation program. So when we continue on our next stream, live stream, we're gonna get into page 25, document 26, but paragraph 87, and it looks like this section is going to be about the TSDB secret ex parte nominating process. Anyway, thank you for checking out this stream here. The first time we did it. Hopefully it grows. Hopefully it continues to provide some value to whoever it is that might be interested in this kind of stuff. But I feel like all Americans, if I could add my opinion, all Americans should be interested in this because this has to do with our rights, unalienable. You dig? So, we'll dig into it and we'll get some more done anytime we come back on. But thank you for checking this out, and let me see how to end this joint. Let's see. Stop it right there, I think.